Can everyone hear me better now?
Yeah.
Perfect. Thank you. Ladies and gentlemen, welcome, and thank you for being here today. Please turn off any cellular telephones to avoid interrupting these proceedings. There are no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that may come before the Special Master, we ask that everyone show mutual respect for one another by listening quietly to each other, each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These are hearings conducted by a Special Master, that is me, my name is Andre McKinney, the purpose of which is to give any alleged violators the opportunity to contest the decision of the Code Enforcement Officer, which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the Special Master assigned to hear today's cases. My responsibility is to act much like a judge in a court, and that is to hear cases presented by the Code Enforcement Officer and to hear contradictory arguments presented by the alleged violators. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath, including the Code Enforcement Officer. These hearings will not be conducted in accordance with formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or Code Enforcement Officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witness, regardless of which party first called him or her to testify, and to rebut the evidence against him or her. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a Special Master are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the Code Enforcement Officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. I have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the Code Enforcement Officer's decision, I must find that there is substantial competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged. If I affirm the decision of the Code Inspector, my order will specify the amount of the civil penalty, the administrative cost of the hearing of not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the town, may appeal a final order of the Special Master to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the Special Master. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be overturned. If you are found guilty of the civil violation as charged, you will be assessed an administrative fee of $100. The city representative will present their case first, and the alleged violator will present their case thereafter. I will consider all evidence and render a decision after all arguments are heard. All those who intend on testifying in today's proceedings, can you please raise your right hand? If you plan on testifying, kindly raise your right hand. Okay, perfect. Do you swear and affirm that the testimony that you provide in these proceedings will be the truth, nothing but the truth? Say, I do.
I do.
Okay. Officer Ramirez, we can now Call roll.
All right. Chief Co-Compliance Officer Jocelyn Ramirez present.
Brian Sherman, Assistant Town Attorney.
Andre McKinney, Special Master.
Nasli Cardona, Code Compliance Clerk.
Mary Carey, Building Clerk.
Next, we have the adoption of the minutes for March 2024.
Any amendments there too?
No.
Minutes adopted as presented.
Next are the adoptions of the agenda, deferral additions and modifications. Item 5.1, case 7531 has been removed from the agenda. Item 5.2, case 4381, removed from item 8.2 and added for an extension of time.
The agenda is adopted with the modifications as so noted.
Okay. And we already did the
Swearing in.
so we can continue to our first case, which is case 6829.
Good morning, Clerk, Honorable Board. My name is Lorenzo Cobiella, Gastesi Lopez Mestre. Office is 8105 Northwest, 155th Street, Miami Lakes, Florida, 33014. I am here on behalf of my client for this, which I believe is a fine mitigation matter. He's completed all the necessary tasks, completed final inspection, and we're here seeking a reduction of fines.
Yes, I will present the case, and if you wish to add anything after.
If I may, can you restate your name? It was I couldn't discern exactly, and maybe pushing back the microphone, the acoustics.
Sure. So my name is Lorenzo Cobiella,
Okay, Mr. Lorenzo.
and I'm here on behalf of Pembroke Park Villas LLC.
Thank you.
Okay. Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6829. Property owner Pembroke Park Villas LLC, care of Piquet Law Firm PA. Site address 4945 Southwest 41st Street, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail March 28, 2024, posted to the Property and Town Hall April 5th, 2024. Is town's motion to abate the fine of $42,148.50 and reduce it by 85%. The total amount is $6,457. Oh, no, sorry, I think I'm reading off the wrong case here. Apologies. Nasli, can you go grab that case file? Sorry,
Which one?
my scannings is not showing correctly. The 6829.
And
I
Officer,
believe the amount is much less.
and just for the record, for today's agenda, that's appearing as section 9.1 and 9.2 respectively.
Yes. I'll proceed. Hold on a second. I'm getting a little confused here because on the
I'm
agenda, on the sign-in sheet,
There's two matters.
Correct.
Here.
595 and 6829. So it's 10.2. That's
And
case 6829
And 10.1.
and 10.1. Thank you. This is no. That's
6829.
okay. Here we go. The actual amount is $28,998.50, and the reduction's 85%. That's a total of $4,485. That includes the admin fee, the recording lien fee, and the release of lien fee. That's for case 6829.
The agenda reflects both case numbers, so we're referring to section 10.1.
Right.
Okay, thank you.
All right. And then for case 8595, same form of certified mail for the abatement hearing. The total amount is $7,600 and the reduction is 85%. That is a total amount of $1,225. That includes the admin fee.
In that case is section what, 10.2?
Yes. Which I have to make a administrative correction there, which the case is 8595.
Okay, thank you. And Mr. Lorenzo, for the record, you're also here on case number 8595 on the agenda 10.2, just for the record.
Yes, for the record.
Okay,
Yes.
very good. Officer Ramirez, anything else?
No.
Okay, Mr. Lorenzo, I'm not sure if you had correspondence with the town, but with regards to the mitigation amount, the town has reduced it to 85%. For case number 6829, we're looking at $4,485, and for case number 8595, we're looking at $1,225. Any objection there too?
We have no objections.
Okay.
Thank you.
If there's nothing else, I'll give my oral pronouncement based on the testimony evidence presented. There is substantial and competent evidence to support the abatement for case number 6829, $4,485, and case number 8595, $1,225. Both of those mitigated amounts must be paid within 30 days. Otherwise, the original amount will resume.
Okay.
If you could take a seat, you'll get an order.
Fantastic.
Good luck
Thank
to
you
you
very
and your
much,
client.
Magistrate. Thank you all, and have a great
Yeah.
one.
This is 6829. This one is 1225. Thank you. We can call the next case.
Next case is 5467. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5467. Property owner Francois Charbonnet, Judith Charbonnet. Site address 323 Marine Drive, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail March 28, 24. Posted to the property and town hall April 5th, 2024. It is the town's motion to confirm the fine of $60,700.
$60,000.
$60,700, and the property is still not in compliance.
I just have the permit reinstated. The only thing that's missing on this permit is the plumbing.
Okay.
Okay, final plumbing, that's all that's missing. I
Okay.
just reinstated the permit, and I can probably finalize that in the next 2 weeks.
Okay. Is your mic on by chance?
Good. 1, 2.
Press
Yeah.
the button.
Okay, can you hear me? Okay, sorry about that. So yeah, I just got the permit reinstated. I can resolve the problem. Like I say, electricity has passed final, AC has passed final.
And you're here
Things
on
left,
behalf
it's
of the
plumbing.
owner?
Huh?
You're here on behalf of the owner?
Well, on behalf of the owners, and I'm the contractor who was hired to assess the situation because he was caught doing the work without permits. So I put mine in there. Mistake from my part, anyway. And the guys has Yeah, he fought to cancel. That's why he wasn't here. That's why I didn't close the permit.
Okay. All right. So after the permits are completed, let me know, and then the owner can request mitigation.
Okay.
Right.
Can I ask a question? Why $60,000?
This has a crew of $100 per day since August 2022.
Okay. We're not making aware of that. Anyway, okay. So I got 2 weeks. Is that what you're saying?
As soon as possible. So,
Yeah. It should be resolved. It should be resolved by the end of next week.
okay.
Okay. Is that all?
I'm gonna give my oral pronouncement,
Yes.
Mr. Donald.
I'm sorry. That's why I was asking.
No,
Is that
it's okay. And Mr. Donald, you've already stated that you're here on behalf of the owner. And I'm curious, can you please advise, when were you hired?
after you got caught doing the work without the permit?
Okay. So you've heard, we're here to confirm the fine. You'll communicate that to the owner. You've already added that you are working on getting the property into compliance. I will communicate to you to urge the owner and yourself to please get the work done because the fines they're accruing.
Okay.
Okay, so I'll give my oral pronouncement. Based on the testimony and evidence presented, there is substantial competent evidence to support the confirming of the fine. The property still remains out of compliance. The amount confirmed today is $60,700. The daily per diem accrual fine of $100 per day will continue to accrue until the property comes into compliance. Okay?
Yeah.
If you could wait, and you'll get an order. Next case.
Next case is on 7.10 on the agenda, case 9160. Chief Code Compliance Officer Jocelyn Maris for the Town of Pembroke Park, case 9160, property owner Numo Inc., site address 4450 West Hollandale Beach Boulevard, Pembroke Park, Florida. A notice of violation was sent by regular mail February 16, 2024. A notice of formal hearing with a copy of the notice of violation and affidavit of noncompliance were sent by certified mail March 28, 2024, posted to the property and town hall on April 5th, 2024. The violations are: item number 1, install plumbing and sinks, including bathroom sinks and toilet without a permit. Item number 2, installed office and storage room, tenant build out without a permit. Item number 3, installed cameras and added electrical without permits. Item number 4, installed tankless water heater without permits. Item number 5, cut wall to install a wall AC unit without permits. Item number 6, window signs are covering more than 25% of the window. Remove 75% of window per window. Remove 75% of the signs per window. Item number 7, Divya by Cynthia is operating without a business tax receipt or certificate of use. As of February 28, 2024. Item number 1 has not been corrected. Item number 2 has not been corrected. Item number 3, the business owner showed that the cameras that they had there on the ceiling, they've removed them from the ceiling and to prove that they were plugins. So that has been corrected. Item number 4 has not been corrected. Item number 5 has not been corrected, and inclusive, they added 3 AC mini splits without permits. Item number 6 has been corrected. Item number 7 has not been corrected. And so it's my recommendation to give 60 days to correct all the outstanding violations, if not a per diem of $500, since this is a repeat offense, reference case 6399 and case 5471. And the final orders have been entered into the record.
Okay, can you please state your name and your relationship to the subject property?
David Pugani, I'm the owner of the property.
Okay,
Okay, good morning.
good morning.
Regarding 4 and 5, we'll go along with the 60 days, and we are in the process of doing that. Can I ask questions, Mr. Ramirez, please? Can I ask?
Yes, you can. Give her one moment.
Sir, can you please speak in the mic?
Oh. Okay. Mr. Ramirez, do you know when the sink number 1 in the bathroom was installed or the toilet installed? Do you know the date or who installed it?
Upon inspection, those sinks, 2014, we don't know who installed it. It could be, I don't know how many tenants you've had there.
Right. So you don't know when it was installed, too?
2014, they're from 2014. Those sinks and toilet.
2014?
Yes.
You sure about that?
Yes.
Okay. I have an email from the manufacturers, okay, which they are, can I give it to you?
Yes.
Okay.
Show Officer Ramirez first.
Okay. These bathrooms were installed. Oh, I'm sorry. These bathrooms were installed in 1990. That's the company, actually have, confirmed that they were selling these items in 1919, in the end of 90s. Okay. The other things, Ms. Ramirez, number 2, do you know when the storage unit was installed?
The storage units?
Yeah.
No,
Do you
but I
you
know
don't-
that there's no permit for it.
Okay, so you don't know when it was installed? It was installed 5 years ago, 10 years ago, or 20 years ago? You don't know?
No.
No. Your Honor, this is very upsetting to me because Ms. Ramirez, wrote down a violation for 4426 for not having a permit for the air condition. So we went there with the building department, with her, and all this entourage, and they showing me that, you need to have a permit for installing the air condition unit. 2 minutes later, the owner came and showed us all the permits. He said, what are you guys talking about? Here's the permit. All of a sudden, you saw everybody disperse like I had COVID. They disappeared. They didn't want to be part of it. This is very, it's for Mr. Ramirez, is you are guilty until proven innocent. Not the other around. She didn't have the time to go and check even in the computers to see that there was a permit there. Okay? And the reason for that, and I can tell you the reason for that, and maybe the attorney will know, the building department asked for 5 new cars for the department. And the city commissioners and the mayor asked where the money is coming from. He promised them that the violation will be tripled and the fees will be collected will be tripled this year. And this is what happened now. She keep up making up stuff. She doesn't know when it was installed. She have no evidence it was installed. She doesn't know if it was installed in 1999 or 2001. But she keeps making this accusation without any evidence. And this is, this is wrong. This is wrong. You're not, it can work in Russia or can work in Iran, but in this country, you're innocent until proven guilty, not the other way around. This has to be stopped.
Madam Magistrate.
She's under pressure maybe to provide, to triple the amount of fees, but that's not, she's going after small businesses. And this tenant spent 2 days in a hospital because of her aggravation and stress.
Madam Magistrate, if I may, I just have a few follow-up questions.
Yes, you may.
Thank you so much. Ms. Ramirez, when did you conduct your inspection?
I conducted based on the photos. Let me get the date for you. This was July 14, 2023, and I want to add that this was brought to my attention by the building official. He was the one who suggested that those offices are not built up to code. And we also went out there with the chief of mechanical, who suggested that multiple AC air conditionings were not up to code and were installed incorrectly.
As far as the, by code, what code are you referring to?
The Florida Building Code.
And did you do a review of the city's records
Yes, I did.
regarding for permits? Were
Yes,
you
I
able to
did.
find any permits?
No,
And you have to install with the permit, correct?
correct.
And you're supposed to apply for the permit before you actually conduct any installation, correct?
Yes,
Thank you. Madam Magistrate, it doesn't matter when it was installed, the fact that it was installed without a permit. If we had permits, we would know when it was installed. At that point, the city has reached, again, this is the hearing of which in order for the city to prove the violations, and the level of evidence that is required is competent and substantial evidence. Given the evidence and testimony and presentation of Ms. Ramirez, as well as the pictures which we are submitting into the record as the exhibit, and she personally saw these pictures, again, with the information provided by the building official, that a violation does exist. And the city, under Chapter 162, is agreement that the owner should be given a reasonable time to comply and then a fine thereafter.
Can I say something? Do you have any permits after 2005 from the city? Well, let me give you any information. You don't have any permits. Anything done before 2005 was burned in fire or in flood, but you don't have any permits. In other words, if it's done in 2001, you don't have anything to prove that this done without the permit. So you guys are fishing right now. You're putting stuff on the market without even evidence. You know, in a court of law, this is not going to work. You can't come and say, I don't know when it was done. 5 years ago, 20 years ago, I don't know. 15 years ago, you don't know. You don't have a proof. If you had a proof, you would have stopped it a long time ago. But if you tell me 2014, where you were from 2014 to 2024? Why are you coming now to say in 2024, like 4 tenants been replaced or changed already hands? I mean, this is going too far when you don't have anything and you try to make up stuff.
Mr. David, thank you so much for.
I'm sorry, I'm a little bit.
No,
you know.
I understand. I do want to clarify also. These proceedings are not criminal proceedings.
But they're recorded, and I wanted to
yes.
have this thing on record.
Yes, and you are very welcome and free to have
Thank
it on
you.
record. I just want to clarify so we understand these types of proceedings. This is not a criminal court of law. And with code enforcement proceedings, the owner of the property, this is set forth in the statute, is responsible for violations, even if he or she did not create the violations, did not perform work that creates a violation. Tomorrow we could have a hurricane. Today, no hurricane, no violation. Tomorrow we could have a hurricane and violations are created that exist. I'm using that as an example to show that there doesn't need to be an intent on part of the owner of the property whereby they intentionally sought out to violate the town's code or the Florida building code.
But they're not violation. You know, if it's done before 2001, according to the company who made this toilet, okay, if it's done before 2001, there is no violation because it could be a permit was done there at that time, and they don't have a record for that. Nobody has the records. They don't know. But, you know, it's just, you know, just looking at something and say, I think there was a violation.
And
It
I'm
just
glad,
doesn't make any sense.
I'm glad you brought up the email because I did have a chance to read it, as did, for the record, the code officer and town attorney. And with respect to the email, what it actually says is that the writer of the email isn't even sure as to when the toilets were actually made. They're saying around the 90s.
Right.
Right. And the email goes on to say that it acknowledges that there's not even a model number.
Right.
Right. So this isn't conclusive. Does that make sense? The other thing also too is I don't know exactly how long you've been the owner of the property, but while records exist, owners also possess records that support whether something was done according to a particular code or building code, town code, Broward County code that also exists. In this case, Mr. Officer Ramirez, correct me if I'm correcting this is a matter of it getting a after-fact permit and inspection. And so that resolves that.
I'm the owner of 2003, and when I moved to, and I bought the place over there, that toilet and that unit was already there the same way, even before she was working in Pembroke Park.
And,
Okay.
and that may very well be the case, but it goes back to what I said originally. The violation does not suggest you created the violation. It simply states that the violation exists on property that you own.
Yeah, they don't say the violation. They say there was not done without the permit, not the violation. This is not, the violation is the permit.
Okay, so that we don't go into circular argument. In a nutshell, your predecessor, right, for argument's
Right.
sake, may have been the one to install this item.
Right.
And they may, and there's no permit to show, and you've not produced one from the prior owner.
And the city doesn't have a permit to show.
I understand that. But to ensure that this exists on the subject property per code, you as the current owner now must procure an after-the-fact permit.
I'm the one who have to prove that I'm innocent, not.
That's not what
she-
no, that's not what I said. Code enforcement violations are not violations that are intentional on part of the owner. They're just the fact that there's a violation that exists on your property. There isn't a permit on file. And so I hope I've explained myself.
Yeah, but again, I think it's a mistake here because the violation is without the permit, not the toilet was installed. It was installed. She claims that the toilet installed with no permit. The permit could have been 2001. The city doesn't have a permit evidence of that. Okay,
And
so
Ms.
why
McKinney, if I
would?
may?
Yes.
Ms. Ramirez did say that this was given to her by the building official because, from their observation, it was not up to code. And with that, with the information, I'm assuming is going to say that it was never up to code. Because again, they'll be able to see that. Otherwise, they wouldn't have referred that over to her to pursue.
And that's perhaps why there's no model number. I don't
You're
know.
going, he said, you don't know even the fact. You don't know the guy told you. This is, he said, she said, and you don't have any evidence. Okay, that the toilet is not even done permitted in the right way. You guys making up stuff.
Madam Magistrate, the building clerk just gave me an email of a public record request from 2001 to 2006, permits for 2001 to 2006. So those permits were provided to Mr. Bugami. So they do exist. As he's saying that we don't have permits from 2006, they were provided to him from 2001 to 2006 as he requested for his property.
When did you provide it to me?
The building clerk gave me this email. You can see it.
Let the record reflect that Officer Ramirez is handing over Mr. David correspondence that reflects a public records request concerning the subject property.
And we'll submit that for the record as well. And we'll submit that for the record as well.
Thank you.
I have to look at them. I don't know.
No,
Can I
absolutely.
keep it?
We can provide you a copy. I'm sure that they already emailed it to you as well, because this is the email thread that they provided it to
Anyway,
you.
just to me, again, if you don't know when it was done,
Officer
if it was
Ramirez, may I take a look?
2001, 2002, 2005, you cannot go back 20 years later and say you don't have a permit. This is just basically to collect fees. Unless you have evidence that somebody did something, you can't come and ask somebody for fees and permit and stuff, because
The magistrate, if I may.
Yes.
In closing, the city would like to essentially just state that, unlike the argument being presented, it's not a matter we have to prove when it was done. And the whole idea is we don't know when it was done because there's no permit. If there was a permit, then we would have that on file. And the search of the file showed that it wasn't done with a permit. The actual unit itself, it's as you said, the email was installed at some point, whether it was done used or bought secondhand. Again, who knows? But at this point, though, we don't have to show when it was done. I'm saying this also for the record as well as the respondent. We have to show that it was done without a permit. And the evidence presented shows that it was not installed according to the Florida Building Code. Therefore, with the search of the records, the absence of a permit together reaches the city's evidentiary burden of competent and substantial evidence.
You have anything else to add before I give my oral pronouncement?
Again, I'm disagreeing because obviously I think this is done prior to 2003. And if it's done prior to 2000, when I bought the place, okay, it shouldn't be coming back 21 or 22 years later and saying you need a permit for something that, who knows who did it, if it was done originally, nobody knows.
Right, but as the town has presented, and I understand your position, the violation is that this was done without permit. And I understand what you...
You see a toilet, you say there is no permit. How do you know it was not originally done with the building?
I understand your position. The town has also submitted public records requests specifically requesting or seeking permits for your property for the relevant time period that you've noted on the record that there are no permits. In fact, there are permits, but there's no permits per the record and the evidence submitted for the violation here today. And so to correct that, you have to apply for an after-fact permit. That's what the code requires.
Yeah, I really believe it's wrong. It's like going to your house and asking, and seeing something and say, well, okay, you don't have a permit for that. You will say, well, I bought the place 5 years ago, 10 years ago.
Right, and when you purchase the property isn't per se relevant as to the existence of the violation. These violations attach to the property, and whoever owns the property is responsible for the violation. Testimony of Officer Ramirez, how this violation came to light was through the building department and reviewing and taking a look and seeing that it doesn't appear to be installed up to code. So with that said, unless you have anything further that's new to add.
Can you tell me why the toilet is not up to code?
You'll have to seek that response from the building department. That's the department that you would have to apply for the after-fact permit. Correct me if I'm incorrect, Officer Ramirez.
Correct.
And so you can sit down with the building official and or his designee to be able to go over the violation. Likewise, if you find in your possession or the person whom you purchase the subject property, if they produce permits, you can certainly come back. Is that correct, Officer Ramirez?
Correct.
Because that would be contradictory evidence that you possess from the predecessor showing that the toilets were installed with a permit. In the meantime, to correct that violation, you do have to apply for an after-fact permit. You are going to get copies of the public records requests. You can take a look at them. Officer Ramirez is available for you to speak to. Likewise, the building department.
Madam Magistrate, the records were provided via email.
Okay.
All right, thank you.
Okay. If there's nothing further, I'll go ahead and give my oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to support the existence of a violation on the subject property. Mr. David, you're ordered to come into compliance. Officer Ramirez, that was 60 days.
Yes.
60 days, or a per diem fine of $500. This is a repeat violation. For the record, the case numbers reflected for the repeat violation are case number 6399 and case number 5471. You are assessed $100 for today's hearing. Mr. David? Okay. You can have a seat and you'll get a copy of your order. Thank you very much. The first page. Okay. Next case.
One moment.
Brian, can we put this in the hearing file?
Sure.
Next case is on section 7.2 of the agenda, case 6658. Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6658. Property owner Lidiana Plonsky. Site address 3140 West Honda Beach Boulevard, lot 438, Pembroke Park, Florida. A notice violation was sent by regular mail, January 28, 2022. A notice of formal hearing with a copy of the notice of violation and affidavit of noncompliance was sent by certified mail, March 28, 2024, posted to the property and town hall, April 5th, 2024. The violations are for item number 1, prohibited outdoor storage, remove all material miscellaneous items and trash. This has partially been corrected. Item number 2, replace water heater without a building permit. This has not been corrected. Item number 3, modifications of the addition done without a building permit. This has not been corrected. Wooden deck and awning added to mobile home without a building permit. This has not been corrected. And item number 6 and 7 and 8 are regarding exterior maintenance, to remove dirt buildup, trim overgrown trees, excessive amount of dead vegetation around mobile home. And lastly, item number 9, installation of cameras without a building permit. The exterior maintenance has partially been corrected. The property owner has made an effort to clean up the property. And item number 9, the installation of cameras, I will have to inspect to ensure if they're plugins. So I'll have to get with the owner about that. But as the moment, I have not verified that, so it needs to be corrected. I'm recommending, I know that the property owner mentioned that she does have financial hardship, so I'm suggesting 90 days. This is a first time violation with a $100 per diem and a $100 MMP.
Good morning. Can you please,
Hello, good morning. Liliana Polonsky.
and your relationship to the subject property?
I know have I know have good English. Is possible she help me?
Any objection by the town? Is
Doesn't
there
feel comfortable translating.
is there someone in the audience who speaks Spanish? Okay.
Thank you.
Who could kindly translate for Miss Liliana? Okay.
No talk
rush.
Spanish.
Don't all rush at one time, but I do appreciate
you.
volunteers.
Thank you. Gracias.
Can you please state your name for the record?
Humberto Ramos.
Okay. Thank you, Mr. Ramos.
Thank you.
And for the record, Mr. Ramos is simply interpreting. Can you ask her what is her relationship?
Ms. McKinney, if I may.
Yes.
Mr. Ramos, can you just raise your right hand?
Oh, yes.
Yeah. Do you swear to interpret from English to Spanish and Spanish to English to the best of your ability? Do you
Yes.
do you swear or affirm that you're going to translate from English to Spanish and Spanish to English to the best of your ability?
I do.
Thank you so much.
And Brian, let's just, town attorney, let's note for the record, I know Mr. Umberto, and I think the other gentleman, Ramon, they'll need to be sworn in when their case is called.
Okay.
Okay. Miss Liliana, did you understand the officer?
Dime.
¿Usted entendió a la oficial?
No, no entendí, pero la señorita, cuando llamé por teléfono, me lo leyó, me tradujo.
She called over the phone, and one of the staff members translated for her.
If you could please speak into the mics, just so we can have an accurate record.
Sure. She called the offices, and the staff member translated for her. So she's familiar with the case.
Okay, so we're here because the violations still exist. Many of them still exist on the property. And so therefore, the town is asking for a final order, time for her to comply before the fines start to run, if you could translate that.
Ella dice que todavía no han resuelto las violaciones y entonces el pueblo está pidiendo que, claro, tienen que resolverlo, pero que le va a dar un tiempo antes que le van a tener que cobrar.
Ok, yo le quiero decir a la señorita que yo compré y tengo los papeles del tráiler Mobile Home en esas condiciones. Yo no hice ningún cambio absolutamente. Simplemente que me caí en el deck y les cambié las maderas y las maderas, con permiso de la asociación, fueron cortadas y tiradas en el boque de atrás. Y yo tengo acá el papel donde la señora del tráiler, yo compré en el año 18 en esas condiciones. No hice ninguna violación.
She says that she bought the trailer in 2018 in the current condition. The only changes that she has made were to the deck because I guess it was deteriorated and she fell. So she, basically that's all she's done, the deck.
Gracias.
Okay, you can let her know. I understand that, and she very well may not have made any changes other than what she's stating. However, because she's the current owner, she's responsible.
Que ella entiende que usted compró el trailer en las condiciones que está, pero como usted es la dueña actual, usted es responsable para cualquier cosa que se haya hecho anteriormente, sin permiso o cualquier violación que exista.
Aunque haya sido hace 10 años antes.
Sí. Y entonces el problema es que cuando hizo arreglo, quizás eso fue el caso de la violación, pero entonces los inspectores notaron otras cosas.
Claro. O sea que me tengo, la pregunta es, yo me tengo que hacer cargo de todas las reparaciones, a pesar que lo haya comprado hace 6 años.
She would like to confirm if she has to be responsible for addressing all violations, even though she bought the building or the trailer in its current condition.
Yes, she does. The violations go to the property, and whoever owns the property is the one that's responsible for that. That is how Florida law for these types of proceedings are set forth.
Dice que sí, que por la ley de la Florida, la persona que es dueño de la propiedad es responsable por cualquier violación que exista.
Después de tanto tiempo.
Sí.
Okay. Okay.
The town is recommending 90 days to come into compliance. If not, a $100 per day daily fine will accrue, and $100 will be assessed if my oral pronouncement finds that the violation exists. Will be assessed for today's hearing. If you could let her know that.
Que comenzando de hoy, la ciudad te da 90 días para resolver las condiciones y que si no lo resuelven en esos 90 días, te van a cobrar $100 por día después de ese...
90 días.
Sí, después de los
3
90
meses.
días.
Ok. Yo le quería aclarar a la señorita que hay puntos de ahí que no están correctos. Las cámaras son de pila porque robaron, me abrieron el carro. Entonces pusimos esas camaritas con pila. Yo a la señorita Jocelyn se lo dije. Eres tú, ¿verdad? Las cámaras.
Tell her that when I mentioned it, that I said that I have to inspect that those are battery operated. Because right now, how they are installed, there's some wiring. I just need to make sure that they're plugins.
Ella tiene que regresar para inspeccionar las cámaras y confirmar que son
Perfecto.
wireless.
El tema de la limpieza, yo estoy soplando constantemente. Lo que ocurre es que el parque no me ayuda. Me dicen, junte la basura en un rincón y la señorita que pasa con el carro, yo lo levanto. No lo levantan. Yo no tengo más edad, pago para que limpien el techo, pago para todo yo. Soy una maquinita de pagar. Pero no puedo hacer más, tú sabes, no puedo porque se me va de las manos, porque no tengo ayuda de ellos. No, es imposible.
Can we have a translation?
Sure. She area. She, on her own, she tries to clean and maintain the property, but I guess the park or the association, they are not following up with their part of the cleaning. So then, obviously that kind of limits her because she depends on them to pick up the garbage that she piles up. So, but she pays services that clean her roof and that clean around. So she's kind of limited with that.
I did speak to the property managers. What I was told is that every mobile home owner is responsible to clean their lots. I know she's doing the best she can, but please let her know as well. I've mentioned it to her before. When she inherits violations, we do have an amnesty program. She just has to show that that's her primary resident and proof of ownership. And she can qualify. The amnesty does help with the code fines. It helps with the permitting process. There's still fees, but it assists. So that program is available to her.
Ella dice que hay un programa de amnestidad que ellos tienen que ayuda a la persona que...
Ella me lo dijo,
sí.
Estoy muy agradecida, gracias. Sí, ella me lo dijo por teléfono.
So when she's ready to speak to Mary, and she'll help
Yeah.
her with the application.
Voy con María.
Ok. Cuando estés lista que...
Tomorrow I go with Mary.
Ok.
Okay, I'll give my oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The property owner is hereby ordered to come into compliance in 90 days or face a $100 per day daily fine. She's also assessed a $100 administrative fee for today's hearing.
Lo que había dicho
90
antes.
días.
Te dan 90 días.
Y si no, $100 por día.
$100 por día y es $100 por hoy, por el hearing de hoy.
Ok. Son las tres violaciones principales que dicen que está la puerta de entrada, el water heater y el deck que hicieron, ¿verdad? Esas las tres, porque el resto no lo hice. Es decir, está limpio, no hay plantas feas, ni cámaras, ni... Son esas tres cosas que tengo que resolver, ¿verdad?
She wants to confirm the three main violations. She's mentioned the water heater, the entry door, and the deck.
Right, and just show me that the cameras are battery operated, as she mentioned.
Que también lo de las cámaras.
Ah, sí, no, eso no hay problema, esa pila, pueden abrirla de atrás, de adelante. De cámara y la puse porque me abrieron los carros. La señora Marlene sabe de eso, vino la policía, o sea que está todo asentado.
Okay.
Sí. It's good. I need
Okay.
work.
Good luck to you.
Thank you. Muchas gracias.
If she could just wait for a moment, they'll give her a copy of the order.
Si esperas un ratico te van a dar una copia.
Sí. Thank you so much.
We can call the next case.
Next case is section 10.3 on the agenda, case 8439. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park. Case 8439. Property owner 5525 Southwest 41st Street, Pembroke Park, LLC. A notice of hearing to abate fine was requested in person on April 4th, 2024. It is the town's motion to reduce the fine of $42,148.50 by 85%. That total amount is $6,457. That includes the admin fee, the recording lien fee, and the release of lien fee.
Officer Ramirez, that was a mitigation reduced to $6,547.00. Thank you. Hello, can you please state your name and your relationship to the subject property and your position with regards to the mitigation recommended amount?
Yes, my name is Ross Lanham. I work for a company called All Repair and Restoration out of Boynton Beach. We represent the owner who retained us about 30 days ago to resolve this situation.
Okay.
Since that time, we have filed a permit, we have taken care of the work, and we have passed the inspection. In regards to the settlement, the owner is asking if we can accept a $4,500 settlement.
Officer Ramirez, how many days was the property out of compliance?
168 days. And so that would be from October 16, 2023 to April 1st, 2024.
When was the property cited?
April 27, 2023.
What's the town's position with regards to the counteroffer?
I present the standard for everyone
Okay.
to keep it equal.
And this is owned by an LLC, correct?
Yes.
Okay. 80, yes.
Oh, Ms. McKinney, may I ask a question?
Yes, of course.
Are there any other special circumstances encountered by the owner, or are you just asking for an additional reduction?
No other special circumstances. I think what created this over time was just turnover local management. Even the current manager who's standing right next to me is very short term. I think it just got out of control and they eventually hired us.
Understood. Thank you.
You're welcome.
No further questions.
I have a question. Is this the first violation on the subject property?
Give me a moment, I'll check. No. No, it's not. We have a few cases here. Case 6302 was regarding the Florida building, the 40-year safety inspection. Case 7756 was a bee infestation. Case 8243, 82 toilets were installed in the building. And then we have the case 8439. So in a course of from 2021 to 2023, there were 4 violations.
The only other one that was turned over to us was 8243, and we are in the process of resolving that one with the inspector. Those are the only 2 that we have.
Okay.
But as Mr. Ross mentioned, there has been management issues. I've had to deal with, I believe she's my 4th manager that I've met so far in the property. So, and I know that the property was bought out probably 2 years ago. So it was a change in management, change in ownership.
Okay.
It was last year when we purchased the property.
That's
Ma'am,
it.
just put your name for the record, please.
Oh, Stephanie Dunn.
Thank
I'm
you.
the property manager. Yeah,
Thank you.
we purchased it last year in February.
Yeah. I know that the 40-year.
Based on your, I'm sorry. Based on your request, I will reduce it to $5,847. That's a reduction by $700. Anything else before I give the order? Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to support the abatement of fines. The property is in compliance. The property owner amount is reduced from, and for the record, Ms. Ramirez, that was $42,148.50 to $5,847. That amount must be paid, and the original amount resumes. The owner is assessed $100 for today's hearing. If you could please.
I'm sorry, but is the $100 plus the 58, or is that included?
Oh, I'm sorry. Yes, it's included.
I'm sorry, for the abatement, we don't assess $100 admin fee.
Okay.
Since we already included it in the amount.
Okay. That's correct. So 5847.
Thank you.
You're welcome.
Thanks.
Next case.
One moment. Next case is on section 7.9 on the agenda, case 8742. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8742. Property owner Seneca Industrial Holdings LLC, care of Ernest and Young LLP. Site address 2601 Southwest 32nd Avenue, Pembroke Park, Florida. Notice violation was sent by regular mail, July 18, 2023. Notice of formal hearing with a copy of the notice of violation and affidavit of noncompliance was sent by certified mail March 28, 24, posted to the property April 5th, 2024. The violations are item number 1, installed racks without permit. Item number 2, installed wooden structure for a conference room without a permit. These 2 items have not been corrected as of March 28. It is my recommendation to give 60 days to correct these violations, if not a per diem fine of $250.
Is there anyone? Oh, here you are. Good morning. If you could please state your name for the record and your relationship to the subject property.
My name is Rena Adan, and I am the office manager for...
Can you turn on the mic, please?
Rena Adan. I'm the office manager for the property that's being leased from Seneca
Okay.
Holdings.
So what's your position with regards to the officers?
I'm the office manager for the...
No, your position with regards to the violation?
Okay. We previously had a permit application that was put in, and we had submitted plans. They were returned with comments. that we were going to address. That was around November, I want to say 15th. I went ahead and forwarded that to my mechanical engineer, my architect, and throughout the holidays, I did have trouble getting those plans completed and those comments addressed. And at that time, at the beginning of the year, we had a business name change with emails, addresses changed, so we were missing emails from those contractors. So there was several things that were happening around the holidays to prevent us from getting those comments back in before the permit was null and void. So we had just reapplied for a new permit, and that was done on the 15th of this month. And the plans are being submitted by my new permit expediter that I am going to have handle this, All City Permits. And so that's where we're at this moment.
Okay, so it sounds like you're working to correct the violations.
Diligently.
Okay. The town's position is to provide you with 60 days or a $250 per day per diem fine.
Can I respectfully request 90 days?
I don't have any issue with 90 days.
Okay.
Okay.
So
I
the town
appreciate that.
The town doesn't have an objection to 90 days. I will say, because you have noted that the permits were just submitted 2 days ago, and the possibility of comments may occur. So if you find that you're not going to be able to be in full compliance within that time frame, you are strongly urged to stay in contact with Officer Ramirez.
Absolutely.
Unless there's anything else, I'll give my oral pronouncement. Based on the testimony evidence presented, there is substantial and competent evidence to support the town's position that the existence of... Oh, I'm sorry. Once again, the oral pronouncement is based on the testimony and evidence presented. There is substantial and competent evidence to support the town's position that a violation does exist on the subject property. The respondent is hereby ordered to come into compliance within 90 days or face a $250 daily fine. The respondent is also assessed $100 for today's hearing. Good luck to you.
Thank you. Appreciate it.
Next case.
Next case is on section 7.4 of the agenda, case 7378. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7378. Property owner Renaud Deschnes. Site address 82 West Lake Drive, Pembroke Park, Florida. Notice violation was sent by regular mail. August 9, 2022. A notice of formal hearing with a copy of the notice of violation and affidavit of non-compliance were sent by certified mail March 28, 2024. Posted to the property on April 5th, 2024, and Town Hall. The violations are for item number 1, installed 2 additions without a permit. Item number 2, installed slab and deck without a permit as of March 28. Let me see the corrections that I wrote. Those 2 items have not been corrected, but the property owner has communicated within the last week. He is going back to Canada, but he's going to ensure that, at least things get situated. Therefore, I'm recommending 90 days, if not a per diem of $100 and a $100 admin fee.
Good morning. Can you please state your name for the record?
Donna.
And,
Renaud Deschaines.
Is the owner.
okay. Can you say that again?
Renaud Deschaines.
Okay. And you are the owner?
Yes.
Okay. So you've heard the officer's testimony with regards to the violation on the subject property. What's your position?
Okay. Can
What's your name for the record?
José La Douceur.
Okay.
I speak English, so that's why I'm here to translate. We already are in process to find someone because we need plans, and the city, Jeffrey, gave us a list. We called those people. One of them never returned our call, and the other lady, maybe we're gonna have someone, but we're since they're leaving in 2 days, they're asking for 90 days. They're coming back just in November, so we're asking if we can give 90 days first, and then I will request for another 90 days until they come back. But in the meantime, we think we find an architect to draw the plans, and he's gonna remove everything when he comes back and do the permit. But we cannot do the permit without having someone signing the permit and he doesn't have time to remove everything. So he would have time when he comes back in November to start removing everything and do the permit. We already sent, we already talked to Ms. Ramirez and Jeffrey at the city regarding that.
Okay. So just so you understand, also, the town is offering 90 days for
Yes.
all of the violations to come into compliance.
But
Okay.
they're not here. That's the thing. We just received the letter, like she said, like 2 weeks ago. We never got letter before because the mail is not, they don't receive any mail here, and they didn't receive anything in Canada. It's been 2 years their owner. So they thought that, already there was a deck there. So he did extend the shed, but he's ready to tear it apart and start fresh when he comes back in November.
And
So we're
Officer-
asking for, Ms. Ramirez told me that we could also, in 90 days in July, ask for another extension. And then in September, until they come back, tear it apart. And in the meantime, that gives me the time to find someone, because I'm going to be the one talking. They don't speak English.
Right. No, I understand. I can't speak to any future extension requests, but for the violation that is before me, the recommendation is 90 days. I do also want to note, and with confirmation from the officer, my review of the file and per the testimony, this violation goes back to 2022.
And Ms. McKinney, if I may, the town would respectfully object to such a request, understanding that this, deck is without a permit, and he wants to wait until November, which is after hurricane season, essentially, in order to remove it, where we want to make sure that structure is not going to, deteriorate or blow away or something if there was a storm event between now and then. So the town, I think, gave 90 days. I think that's enough time. Again, as the owner of the property, their travel plans and their operations or how they want to conduct themselves on the property is completely personal unto them, and it doesn't affect or excuse the violation.
Can I say something?
Yes, you may.
I know that they received this at the end of and they know, and the inspector knows, that the mobile home parks are mostly Canadian, and they only come here for 6 months because we can only stay for 180 days. And so they have to go back, and they just received this, and have no problem of taking a permit right away for demolishing, and then because we have to take a permit for demolishing, a permit to build, have the plans for the building of the deck. I understand that, and we're ready for that. It took us like 2 weeks to get just the signature of the owner of the park because he's not reachable. So we finally got his signature that he approves, but You have to give us time.
Right. I just want to clear so that there are no misgivings on the record. This violation was issued back in 2022 in accordance with what Florida law requires. Whether or not the owner was aware, that's separate and apart. Now, that's almost 2 years ago, and by your testimony, he is a snowbird. He comes down here. So at some point in time, he would have been aware, aside from the fact of being noticed. So
He said he never received the letter, the first letter in 2022. Quand est-ce que t'as acheté?
Avril 21.
Okay. When was it sent? Because the owner of the other his mobile home, he left, and so we don't know if he received anything or not.
The first notice was sent August 9, 2022. And then the certified mail was sent March 28.
Okay. So they were not here at that time. Even if there's a mail in September, most of the Canadian there, October, they come here, but they didn't receive anything. We don't, I understand the process of the city. I do understand, and we're ready to do our thing. We just don't have the time right now to take it apart, but we're ready to take a permit if we want to be in compliance.
right, and I understand. I just want to clear a couple of things, and this will serve Mr. Renaud. It will serve for him to understand. Albeit he is someone who spends half his time in Canada and half his time here. But this property is his, and he is fully responsible for it, regardless of where he is in the world. And so it would serve him to have someone check on his property, but that's besides the point. For today's hearing, the violation exists, and it has been in existence certainly as far back as 2022.
Okay.
The 90 days is what the town is giving to come in full compliance. What that means is the violation can no longer exist. The architect, the permits, the post-inspection and closing of the permit, all of that has to be completed within 90 days, or a $400 per day daily fine will start to accrue. And as I previously stated, while you've noted intentions of requesting subsequent extensions, that's not before me. We're only here today regarding the violation on the subject property, the time to come into compliance, and the daily fine if it's not in compliance.
Okay. And can I ask, if we're asking for an extension, another extension, when is it, where do I go for that? If it's not before you?
Officer Ramirez.
It is before the special magistrate. An extension will have to be granted by special magistrate. The form that I provided for you is what has to be filled out after the 90 days.
Do I have to?
I have a question. The owner is pulling a homeowner permit? Is that what he's getting?
Yes.
Okay. And he's doing the work himself?
Yes.
Okay.
But he will have the plans for and respect all what they're asking for on the plans.
Right.
Yeah.
Puis le cabanon.
Ouais.
Le cabanon, puis le balcon d'en haut, parce que c'est moi qui l'ai fait, le balcon d'en haut.
Oui.
Parce que la femme avait tombé.
Yeah, he's saying that the shed, he understand that he extended 2 feet, he understand that. But because his wife fell on the deck that was existing, she fell, so that's why he extended the deck. So she at the same level of the door instead of having to one step and fall.
Gotcha.
So that's but he's ready to.
And he's able to get an after-the-fact permit for the deck?
Of course.
You checked with the building department?
No.
Okay. But what you're saying is he's willing to do that when he comes back in November. Mm-hmm. Okay.
If he has to take it apart, he will take it apart and start fresh with, we'll take the permit right now for the, demolishing, because I know we have to take one. And then after that, we need to get the plans, so we need the architect. So
Right.
we have someone in, the lady that Jeffrey gave us, she's to book right now. She maybe could give us during the summer to have
So
the
in the
plans.
90 days, you'll work on getting the plans. is what
Yes, yes.
Okay.
Mais si je peux venir en juillet, comment je dirais bien ça? Mettons, démancher la shed. Oh non, oublie ça, je suis pas capable.
Okay. He was asking me a question.
Anything,
Sorry.
anything else from either side?
No.
No.
I'll give my oral pronouncement. Based on the testimony and, oh, go
Juste
ahead.
une minute. Non, dis donc, le deck d'en bas, là, c'est pas celui-là que j'ai fait. Là, celui-là qui est en bas, lui, est-tu correct?
He's asking that if the deck, the first that you see on the picture of 2006, I think, or 2010, there's a deck already there.
Okay.
Is that one good? Because the other one, he extended.
All right. So we'll probably have to do a reinspection
Okay.
of the deck. So if you can contact me, let me know.
Yeah.
Kind of show me where he did the extension.
Okay.
'Cause I was unaware of the extension.
Okay.
So, and then I can provide those
Okay.
pictures to the building department.
Okay.
C'est quoi?
Elle va dire on va la contacter. Puis elle va venir réinspecter, voir si on peut laisser ce deck-là.
Le vieux en bas.
Oui, c'est
OK,
ça.
mais l'autre,
On
en haut, il
s-
faut l'enlever.
ouais, ouais.
Il faut l'enlever puis le refaire.
Ouais.
On peut-tu le faire pareil?
Oui, ça dépend de l'architecte ce qu'il va dire.
Ah, mais puis si l'architecte, il dit c'est correct, on
Il va
est-tu
faire
obligé
les
de le
plans.
faire?
Il va
Non, non, mais
faire-
si l'architecte, il dit
Il va faire les plans.
il est correct, le plan,
Non,
le balcon que j'ai
il va falloir
fait.
que tu leur défasses, que tu leur fasses.
Ah, OK.
Sorry.
What was the translation?
Oh, he was asking me the deck that he did, the extension, okay? He was asking if he had to demolish it and do it with the plans of the architect,
Okay.
or if the architect said it's okay, he still has to sign on the permit.
Gotcha. All right. So we'll determine that once we see the extension, and the building department can kind of better guide you.
Okay.
Yeah.
All right. Bon.
Quand
Quoi?
qu'elle peut...
C'est ça, il va falloir prendre un rendez-vous avec elle.
Ah, OK.
I just told him we have to take an appointment with you.
Okay.
Okay, thank you. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation does exist on the subject property. The owner is ordered to come into compliance within 90 days or face a $400 per day daily fine. The owner is also assessed $100 for today's hearing. If he could wait,
Why 400?
Yeah.
was it 400? 100, I'm sorry.
Thank you.
I was about to ask it.
Peux-tu prendre le permis?
I literally wrote 100. That's why oral pronouncements are good.
Okay.
If you could step to $100 per day.
Okay.
It must have been my accent.
Bon, tu peux aller t'asseoir.
Quoi?
Parce que...
Fini?
Oui. Ils vont te donner ton jugement.
We can call the next case.
Next case is on 7.5 of the agenda, case 7379. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7379. Property owner Claude Legendre, 84 West Lake Drive, Pembroke Park, Florida.
Yes.
Notice of violation was sent by regular mail, August 9, 2022. Notice of hearing with a copy of the notice of violation and affidavit of noncompliance was sent by certified mail, March 28, 2024, posted to the property and town hall, April 5th, 2024. Violations are for item number 1, installed addition without a permit. This one has been removed. Item number 2, installed wooden fence without a permit. This has not been corrected. Item number 3, installed wooden dock without a permit. This has not been corrected. However, the property owner did communicate as of, I believe, 2 weeks ago. He also too mentioned that he was going to Canada. So therefore, my recommendation is to give 90 days, if not $100 per diem, and $100 admin fee.
Hello, can you state your name for the record for this case?
José Ladouceur.
And your relationship to the subject property or the owner?
He's my neighbor, and he did sign a paper stating that I could be the one doing the permits or, for the inspections since I'm neighbor.
Okay.
And I'm here year round.
Okay. So with regards to the violations, what's your position?
Okay, for the fence, it's those, I know he brought the paperwork for the fence, what they were asking, and I thought he took the permit for that.
Okay.
Did he take the permit?
Mary, are you aware of any permit for
Not at the moment, but she can call me later at the afternoon and I can check the system.
Okay.
Okay. And also for the deck, he did request, it's a floating deck, and he did request for the law, what kind of law you have in the city for this, but no one gave him any information, and he sent it by email so we can know what exactly they're requesting, or if there is, since it's floating, it's not attached.
Right. That
Remember?
was sent to him by email. It was sent to him by email.
Because last night, he called me from Canada,
Okay.
and he said he didn't receive anything yet.
I will resend it, but it was sent. It was sent.
Really?
The same day he requested it was sent.
Which email did you send it? Is it possible to see?
To the one that
You don't know?
To the one that he requested it from.
Town
Okay.
attorney, did you?
Yes, Ms. McKinney, if I may, I just want to just caution, if I may, understanding that the respondent's here, as a friend and a neighbor.
Right.
And she's saying that she has a handwritten, which she shown, it has not submitted it to the city as far as her authority to speak on the issue. And again, we could proceed as a courtesy, but understanding that only the owner has the ability to, of course, present it, and also to be mindful, we want her practicing law without a license as well, understanding that she's just trying to be nice and neighborly. To assist wherever she can, completely understanding. But obviously, a lot of the, this is where the issue is. A lot of the back and forth becomes a lot of hearsay between what they said and what they did receive or didn't receive or anything else. So we can proceed. We can take the testimony, but just again, I would suggest that you give it the appropriate weight.
Oh, no, agreed.
Of course. Again, all the cautions, of course, we want to be helpful. The purpose of co-compliance is to help achieve compliance, not for fines, and understand the situation. But I just wanted to make the respondent as well aware, as well as put that on the record.
And I do want to clarify also, I know you're here as a neighbor. Please show Officer Ramirez and the town attorney, likewise, they'll forward it to me, the letter with regards to. So when the question is asked, what's your position? It's not it's the respondent as far as what's communicated.
I'm sorry. I was really sure that he gave the letter because we made it. He made a copy, so,
I also want to add that when these proceedings are duly noticed in accordance with law, whether the respondent chooses to be here or not, or chooses to have someone stand in their stead, let's say if they're at work, hospital, something going on with a family member, the proceedings can proceed. Oftentimes, respondents, if they themselves want to participate, but for whatever reason cannot be here or have someone in their stead, they can communicate to the town for a continuance of the particular hearing until the next opportune time. But these proceedings can proceed without the respondent being there as long as notice has been duly provided in accordance with law.
Okay.
Okay?
And for the record, I just checked my email. It was a public record request done on April 3rd. And so it was responded on April 3rd. And that email is Claude Legendre
Legendre?
6@gmail.com.
Oh,
That's,
okay.
that's what it was sent to.
We'll add the form provided to the record as we'll also note that it's not notarized and understand it's not your fault. And I'm not saying the authenticity of it, but as far as conforming
know.
with Florida law.
That's exactly what he has a letter that's notarized, but he already was gone, so, you know.
Again, understood. And the reason why we're putting it here is really to protect the record, to protect you to the best we can. It's just a matter of, again, for the proceeding itself. And
Yeah.
we appreciate your desire to assist.
Because I was present when he came to the building department, and we did talk, and he did say that he needs an extension because he's going to be back. And at the time, we didn't have the ruling when he left for the deck, so we have no.
You have to speak with the building department because I'm fairly sure that letter won't allow you to pull a permit on his behalf.
Okay.
The ruling is that he has to pull a permit for the dock.
Right. It's either you have the owner, and again, the owner has to pull the permit or a contractor.
Okay.
Anything else is up to the building department, but that's ultimately gonna be the issue for him.
Okay.
And the property owner did mention that if he knows it's complicated, so that he was gonna obtain a permit for removal, to remove the dock, because he knows that it's complicated to get a permit for it. He would need an architect, and like, as he mentioned, he's in Canada, so his opinion was to remove it, and then when he comes back, he'll do it with a permit, with the plans and everything.
Okay.
But yes, the property owner did come and did mention that his neighbor was going to assist him in the matters.
And for the record, what's your property address?
81,
Okay.
right across.
Anything else?
No.
Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. The respondent is ordered to come into compliance within 90 days or face a $100 per day daily fine. The respondent is also assessed $100 administrative fee for today's hearing.
Okay. And the fee is payable today?
Would she be able to pay the administrative fee?
Today in the afternoon, sorry, or tomorrow.
Okay, where do we go?
To the building department, you ask for Nasli Cardona.
Nasli?
Name is here.
Okay. Because I have to pay for him. That's in Canada. Okay. We're good?
Yes. You'll get a copy of the order. We can call the next case, Officer Ramirez.
$83.52.
While we're waiting for Officer Ramirez so that we can recommence, the two gentlemen that came in after, I think there was one other. I just need to swear you in. Nazi, who was the other person? And Humberto? Humberto, Ramon, and... Okay, can you three please raise your right hand? Do you swear and affirm that the testimony, right hand, are you testifying, sir? Yes. Oh, okay. Do you swear and affirm the testimony you will provide will be the truth and nothing but the truth in today's proceedings? Say I do. Okay. Okay, thank you.
The next case on the agenda, on this list, we have 8352, but there's also another case, so I'll start with the first one. Which is 9501, which is on section 7.12 of the agenda. Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park. Case 9501, property owner Yasim 5401 LLC, site address 5401 Southwest 25th Court, Pembroke Park, Florida. A notice of violation and a notice of formal hearing was sent by certified mail April 5th, 2024, posted to the property and town hall April 5th, 2024. This is a repeat offense referencing case 5382 and 8352, which has been, the final orders have been entered into the record. The violations are item number 1, operating without a business tax receipt or certificate of use. Item number 2, illegal dumping on swale area has become a public nuisance. Remove all trash from swale area and maintain swale periodically and accordingly. As of I believe on Monday, that has not been corrected. The trash has been moved inside the property and there still is no business tax receipt on file for the property. It is my recommendation, because this is a repeat violation, that this be done in 30 days, if not a per diem fine of $500 and a $100 admin fee.
Can you...
I didn't hear nothing. Okay, I understand we have some violation.
I'm sorry. Hello, can you tell me your name? Tell us your name and who you are with regards to the property. Are you the owner, and your name?
Okay, my name is Roger Mimoun. I am the manager of Yasim 5401 LLC. My tenant was here for a long time and he could not wait, so he has to go to work and he left. Okay.
You said your tenant?
What?
You said your tenant was here?
Can your son assist you in this matter, please?
He speaks Spanish?
No. He just has
hard of okay.
Yeah, hard of hearing.
Do you swear that your translation for your father will be the truth and correct to the best of your ability? Okay. Can you state your name for the record?
Dylan Mamoon.
And the mic.
Dylan Mamoon.
Hello, Dylan. Thank you. I just need your father to state clearly his name, and is this his property?
Et il veut te dire que toi tu dis ton nom et ton nom de last name et c'est ton propriétaire.
I said it now.
Okay, because
I already said my name.
Okay, and are you the owner of the property?
I am the owner of the property. I mean, the company it's an LLC.
Okay,
I am the manager.
The president.
Huh?
You're the managing owner? Or,
exactly.
Okay, okay.
He's the property owner.
Okay, very good.
I understand you have a violation.
Yes.
The tenant that I have just took over the property on April 1st. So he really didn't have enough time. He has a company. He's very busy. In fact, he came after for a few hours. He left because he couldn't wait any longer. They call him he's a tow company, and he does also inside. He does body work and things like that for cars that are accidented. So he take care of them too.
Right.
And okay, so what I'd like to do is to ask for an extension for at least 1 month.
We're not here for an extension. We're here on the existing violation.
What?
The
We're not here. We're not here. We're here for an existing violation.
When?
We're here for an existing violation.
So the
About 10 days ago.
yes, give me 1 second. The violation was issued this month.
Yes.
The town is giving you 30 days to come into compliance.
No, because the violation I received on the 4th, they sent it. They wrote it on the 4th of April.
Yes, we're still in. Yes, we're
I did not receive it that day. I received a few days text about, the post office. It's not my fault.
Okay.
I received it maybe a week or 10 days maximum.
Okay.
And I spoke to the tenant. Okay, I told him you have to do it. He didn't have time or whatever it is. It's not enough time for him to do everything. He's alone. That's why he lost his employee. I don't know what happened to him.
Okay. And I understand that. That's between you and the tenant. But for today's hearing, the violation exists on property that you own. The town is giving you 30 days, regardless of who pays for or takes care of correcting the violation.
Okay.
Ultimately, you are responsible for getting the violation in compliance. 30 days.
From today.
30 days from the date of the order, yes.
Okay.
Or you will face a $500 daily fine because this is a repeat violation, and the repeat violation case numbers are 5382 and 8352. Is that correct, Officer Ramirez?
What was the repeated violation? I don't even know.
Okay, that would have been in the notice that you received. But for the existing case that we're on right now, 9501,
Which one is that? Could you tell me the violation?
the violation pertains to not having a business tax receipt, not following certificate of use requirements.
Right.
What?
The first violation is you have someone in the property that's operating without a business tax receipt or certificate of use.
J'ai entendu ce que dit.
The second one is the illegal dumping on the swell area has become a public nuisance. So the swell area has to be maintained.
Swell area and one with the tax receipt.
Right now, the property owner, the business owner, they removed the trash from the swale area and they put it inside the property. That does not correct the violation. The trash has to be completely removed.
I didn't hear nothing. Okay. I didn't hear nothing.
Okay.
The problem is.
Hold on, because we want you to understand what's being said, because this is your opportunity to be heard. Can you translate? Thank you.
The swell area. There's dumping in the swell area.
Okay.
And you said something about the tax receipt, right?
It's not
Let your son finish telling you what the officer said so that you fully understand.
The business tax receipt, okay?
What?
Elle parle de le business tax receipt, okay? And then the swell.
My tax receipt?
No.
The guy, right?
Yes.
Yeah, he has it. He has it.
He does not have it.
I spoke to him yesterday. I signed. You have to notarize the paper. That's why, right? I have to notarize.
Right, and he has to pass electrical.
He didn't do it. I know.
Structural inspections.
He just moved actually on April 1st. You understand? He was in the yard for maybe 2 months.
Yes, but he completely moved in. There's a bunch
Listen.
of trash in the back. He is fully operating.
You're gonna get hopefully tomorrow or the next day.
No, she's saying that there's trash in the back.
Oh, I mean inside or outside?
On the property, in general. Trash should not be on the property.
Outside, some people throw trash, mattresses, and things like this is not ours. And even though it was not ours, we remove it, okay? So people come from the street, put the garbage there, and they have to be responsible for that?
Yes.
Why I'm to?
Because-
I dump a place.
Because
It's not the first time. It's not the first time.
unfortunately, it's your property, and so that
I have to sit there. I have to put. I have all days and night to see that nobody puts the trash there.
We got
What makes sense?
We got a citizen complaint that trees were trimmed from his property and they left it on the swale. When that encourages people to dump more. So when you leave trash on the swale, it comes from your property, and it's almost as if it was initiated by the property owner for leaving trash to begin with on the swale.
Okay, we didn't trim any tree because we have no trees. We have only one tree at the corner. It was not trimmed at all, so it's not my trim. Okay.
We have
The tree?
notaries.
No,
in
it's
the
not mine. It's not mine. What do you want me to do?
We have-
Somebody put it there. It's not mine. I have no tree. You know I have no tree there. Did you see any tree there before? A big tree on the corner?
The business owner.
That tree was not trimmed. You can come
The
and look at
business
it.
owner
Seriously,
said that
I'm
he
not.
trimmed the trees.
I can hear. Huh?
She said that citizen said that you trimmed the trees.
No,
The citizen, they're liars.
Complain.
They are liars, those citizens. I didn't trim the tree because I have no trees.
Okay.
Very simple.
Officer Ramirez, what I thought I just heard you say, and correct me if it's incorrect. One of the business
Because they
owners.
accuse me of something I'm not.
Citizen that lives around the area and the business owner also confessed that, not confessed, but mentioned that he did trim and cleaned up.
This is a business owner in his establishment?
Yes.
Okay, and that person is identifiable?
Yes, but not here.
Right, right, but
Okay, so what am I to do? They
in
can
other
complain,
words,
so.
by name?
Yeah, of
This
course
is an
they complain.
anonymous
They-
person?
No. You have the name?
The name is on the list. Whitney Bixam. I'm sorry.
Okay.
Whitney Vixamer?
Yes.
Okay. Just for the record and to be in compliance with persons who report violations. Again, and I'm speaking to son so you can tell your father. No one is saying he dumped trash and debris on his property, but trash and debris is on his property. And that's been reported by one of his tenants. Okay, so to answer his question, if there is trash and debris on his property, he is responsible for removing it, even though he didn't put it there or authorize it to be there.
But we did remove it. About 10 days ago we removed it. No,
No, it's in the back of your property.
inside the property, he removed it yesterday. He told me. I didn't see it. I didn't see it, really. I didn't see it, really. He told me he removed it yesterday. I'm going to go now to find out if he removed it or not, that's all. But like we said, give me 30 days to fix all the problem. That way I can take care of it, and that's it. What can I do?
Okay. Anything else by either side?
No.
Okay. Based on the testimony and evidence presented, there is substantial and confident evidence to support the town's position that a violation exists on the
Excuse me, but you know it's a Jewish holiday next week. So I need 5 weeks.
I wasn't aware of that.
Well, Madam Magistrate, if I may, the holiday is referring to
Passover.
It is Passover, where the first Seder is on Monday. That's 8 days, or 7, whatever it is. As far as that, however, there's the time to comply recommended by the city is 30 days.
30 days, yes.
And for these violations, again, it's not a matter of these violations can be cured during the next 4 weeks, 30 days.
What he said?
He objects to your 5 weeks.
5 weeks? Okay.
No, he objects. The
Object.
town's position is that they object.
Okay, give me 6 weeks then.
No. These violations can be
Okay,
cured.
4 weeks, fine.
Right.
I'll try
Okay.
to do my best.
Okay, okay. And stay in contact with the town.
Okay.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists. The violations exist on the subject property. The respondent is ordered to come into compliance within 30 days, or a 500 per day daily fine will accrue. This is a repeat violation. Repeat case numbers 5382 and 8352. If you could please, does he have another case?
Yes.
Okay.
So this is case 8352. the same property owner, Yasim 5401 LLC, same address, 5401 Southwest 25th Court, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail April 5th, 2024, posted to the Property and Town Hall April 5th, 2024. It is the town's motion to confirm the fine of $37,600.
Okay, hello again.
This is it?
Okay, so for this case,
is your son coming back?
No, the tenant is over here. I see his truck here, so I thought maybe he'll come.
Here, can we open the door?
I see some.
And then we need to, for future, I know we have people manning the door. We got to make sure that it's open for future here. I know there's a lot of renovations with the building, so we just got to make sure.
Hello, how you doing?
Hello, can you please state your name?
Whitney Vixamore?
Oh,
Can you speak into the mic, please?
Whitney Vixamore.
And Mr. Vixmar, you were here earlier.
Yes, yes,
Okay,
yes.
you were sworn in?
Yes.
Okay.
Yes.
Officer Ramirez, for this case, do you mind just giving a brief summation?
Sorry, I had to run out.
No.
Okay, so for case 9501, this is a repeat offense.
Well, not that case. That case we've already.
Oh, you want the other one?
Right.
Okay,
Because we were interrupted.
This gentleman, the business owner, is related to that case.
Okay.
So that's why I thought you meant that one. Okay. So
It's
then,
a repeat? Because
No, so Mr. Whitley, you were here originally for case number 9501. I did render an oral pronouncement, but what would you like to add since the owner of the subject property did have you here? What would you like to add?
pretty sure he said that, people just, because I added it was just a branch or two, because, I needed to move the gate and everybody started pouring in and that's what made it a mess. So I paid it out of my pocket to clean it up, and I cleaned some more that was inside, whatever the case was, to resolve the situation. As far as the gate and stuff, I just need a couple more weeks because I am working and I'm dealing with contractors that's supposed to come out and they're just not coming out. So I have to keep finding more, other people to fix the gate or whatever issue it is, and also the screening for the gate. But I will in a couple weeks. It should be done. So
Okay, as I stated,
They give us 1 month.
okay, that's fine.
right, as I indicated, we
Just need a little bit of time.
we heard the case, and the owner, who is the respondent,
Right.
was told that the violations have to come into compliance within 30 days, or a $500 per day daily fine will accrue. And regardless of who puts junk and debris on the owner's property, he is responsible for that. So if the owner...
Take care of that. I'm sorry. We did take care of it.
Okay. The other thing also too is when the violations are completely cured, please contact the officer for a reinspection.
Okay.
That's going to be very important before the fines start to accrue, if they're corrected timely.
and I just want to ask you, has all the trash been removed from the
All the
park?
trash.
All the trash, because when I went there, I saw a bunch of debris.
Yeah.
Everything has been removed?
I mean, most of it. The pile that you've seen is removed. I just have to. I would say it's just stuff the wind was blowing around. I just have to clean up a little, but that's about it.
Okay, so make sure it's completely
Right.
clean, and then I will go and inspect. Just give me a call.
Okay,
And
sure.
as far as the business tax receipt, have you submitted your application?
We're just waiting on the notary. That's all.
We have a notary in town,
Okay.
so you can come in and they'll notarize you. They won't charge you but you
Does-
have to sign in person.
The owner has to have to be there to get notarized, or I can just bring the paperwork.
Yes.
Okay. All right.
Excuse me, you have a notary here?
Yes.
She said
Yes. All right. Okay. So, do you want me to summarize the other case that we just?
Right, because we were on confirming the fine for case number 8352.
Yes. Okay. So that confirmation is $37,600.
$37,600. Officer Ramirez?
Yes.
$37,600. Thank you.
And that was for the debris.
No.
No, we're
This
on
is a different case.
Oh, this is a different case.
Case
Yes.
8352.
Yes.
Okay.
You can have a seat. No, you're not. But I do need your father and you to speak in the mic. Okay, so the next case is 8352. And for that case, the town is confirming the fine. The property is out of compliance, and so we're looking at an amount of $37,600, which is still accruing daily.
Calme-toi, ok? Je vais te dire. Elle dit que tu as besoin de payer 37,500.
I have to pay 27,000?
37.
Huh?
No, you're still, that property still is not in compliance. That's how much the fines have totaled because you're not in compliance.
If I comply, everything good.
If you comply, the fines will stop. You can apply for abatement, which is a request to reduce the fines. It comes back before the special magistrate, and then you'll hear the determination of what that lesser amount will be. But first things first, compliance.
So he owes 37,000?
No. After a month, right? If he doesn't comply.
Right now, what we're doing
you have
closing a lien because there hasn't been.
I don't understand. Je pas compris. I don't understand what he said.
It's got a total of 3.
No, 3.
No, just 2 cases. There's a third one?
Oh, okay.
Okay.
5382.
5382?
From which day?
9501.
5382 is was entered into the record as to demonstrate that it was a repeat offense.
Right.
I'm sorry. Yeah. What was the fine? Because he's not
So,
sure what's
if I may, Ms. McKinney, you have 2 cases, 2 separate matters.
Yeah.
One matter, that's the one that we just discussed.
Okay.
As far as the 30 days to compliance, then fines will start. You have another case which have already accrued fines because that time frame has elapsed. You have 2 separate matters, both on today's docket. You have 2 cases. One we just heard. You have 30 days to comply, or fines will start. The other one, fines have already started, and the town is requesting a lien be placed upon the property.
I don't know about that fine at all. I don't understand. First of all, I was sick for a month. I was in the hospital, okay? So I didn't hear that that's a fine. I never received any letter saying that you're going to have a fine starting this day or this day. Never. Okay? This is a problem. There's a lack of communication here. Okay? Sometimes I receive the letter to my home. Sometimes I receive in my PO box. But I always say, please mail all my business to my PO box number. I have it for years over there. This is where I receive all my mail. Okay? So if I'm sick, I cannot open my mail.
It's the same requirement, Madam Magistrate, if I may? Thank you.
One moment, Town Attorney. Officer Ramirez, correct me if I'm incorrect, but for case number 8352, does the record reflect that there was a hearing per an extension request on this matter?
Yes, in the past.
Okay. So
I saw Jocelyn a week ago, and before also. She never told me about that fine that I have. She never told me anything about that. I told her everything's fine. She said, oh.
Yes, an extension was requested, and that hearing took place September 20, 2023.
Okay, so this isn't a new violation, and the point of that is that you were aware. When the notices go out, it's very important that owners of the property read the contents of the notice. It's all contained in there.
What's the violation?
And so...
What's the violation? I don't even know what the violation is.
This was for the silt on the fence is broken and prohibited. The swell area is full of trash. Outdoor storage is prohibited. Swell area has bare spots, requires new sod. So this has been partially corrected. It needs to be fully corrected.
Outdoor storage is prohibited?
Yes.
Yes.
It's not a storage, it's a parking. But I don't understand. We're talking about storage. It's a parking. This is a commercial space. I don't know. I'm not even aware of that. That auto storage is not prohibited. How do I know that? It's a commercial. It's a garage. So why you didn't tell me before? Before he rents it. Did you go there as them?
No, okay, listen. How long ago was this? This was before I got
Yes,
there.
March
So-
30, 2023, when there was previous tenants there.
March 20th, 2023.
See, look at the picture.
28,
Look at the
23?
picture, the picture.
What do you have? This is mine. This is
Outside, yeah, see out there?
this is
But
mine.
I
This is
don't-
mine. I don't understand. What are you doing? I want something like that. It makes any sense to you to give me a violation because of that? Or give me a violation because people throw mattresses and trees in front of my property? I'm responsible for that?
Well, for
Doesn't make any sense. You use your logic, please. This is not mine. This is mine. What am I going to do with this? They did the work on the street here. They damaged my whole here. They removed the grass. They removed everything, and I have to put the grass. I have to remove the stones and everything. Why do you think I'm working for the city? It's not even my land. Outside is not my land. It belongs to the city. Why should I be responsible for that? Doesn't make any sense.
for today's
I
hearing,
have that truck. Is mine. Come on.
Madam Magistrate, I've been out there multiple times.
we're here to confirm the fine. The final hearing has already
I
taken.
love that thing. It's mine.
So,
Mine.
so unless you have anything else to add, I'll render the oral pronouncement. I am going to recommend that you make an appointment to sit with the officer. She's already indicated that
Do you see any storage, auto storage there?
she's already.
Do you see any?
Like I mentioned,
No,
it's
there?
partially corrected, but you still, it's partially corrected.
Partially corrected.
But right now,
It's partially corrected.
Partially corrected.
So,
I had a
so
tenant who didn't pay me for 6 months. I evicted her about a month and a half ago, 2 months ago.
Bah, laisse-la parler. Attends, elle va parler.
no, and what I'm going to recommend is after my oral pronouncement, and your son can help you to make an appointment to sit with the officer. She's already indicated it's partially corrected. For purposes of the hearing today, we're here to confirm the fine. As of right now, all of the violations have to be in compliance for the fines to stop. As of right now, the fines have totaled $37,600, and they will continue to accrue. Is the daily rate $100?
Oh, $37,600.
I believe it's 250.
Yeah, it's $250. I'm sorry,
If you guys, we gotta figure out to comply because what
Mis- Mr. Whitley.
I'm trying to explain it to him because
Yes, and
we
we,
not understanding.
but allow me to finish, and when he gets in order, you can.
Okay, go ahead. Go ahead.
Okay, as I was indicating, we're here to confirm the fine. The fine is $37,600. Based on the testimony and evidence presented, there is substantial and competent evidence to support that the violation still remains outstanding. The fine will be confirmed at $37,600. It will continue to accrue at $250 a day. So, as I've indicated, please schedule a time that you can sit with the officer to ensure what remains to be completed so that the entire property can be in compliance. From there, once it's inspected and confirmed, you can apply for abatement, which is a request to reduce the total fine amount. In the application, you can set forth everything that you want to support your request. Okay.
Let me ask you a question. About a month ago, I asked her, do you have any violation? She told me only the grass. You have to put the the grass to put there, and we put it. That's it. I don't know about any other violation. You understand? So I didn't know that there is a violation from last year. I didn't know about that.
Okay, well, Town Attorney, did you want to add? Because I think that part's already been settled on the.
Exactly. I was going to say, Madam Magistrate, you ruled. Any other comments? And
Yeah.
you can have a discussion with Ms. Ramirez after the hearing.
Okay.
We'll talk with her.
I can hear.
We'll talk with her and I'll explain to you what's going on. Okay?
Oh,
All right,
signed it.
appreciate it. Thank you.
Good luck to you.
All right.
Listen.
Listen. Okay, thanks.
No,
Sir?
don't leave without the order.
Okay, cool.
Where- Okay. loud because he can't hear.
Yeah, but this one.
Like, what do I do?
I don't know.
He doesn't have a hearing aid. You know, to have a hearing aid. Yeah. We can call the next case.
Six.
Next case on the agenda is 7.3, case 6661. Chief Code Compliance Jocelyn Ramirez for the town of Pembroke Park. Case 6661, property owner Roger Perez and Yadira Esquivel Arango. All right, that's what I have as for the title. Have you registered with the park?
It's actually, I'm not a resident there. My mom just put me as the main property owner.
Okay, let me finish presenting what I have here, and then you can state what you guys have. Okay. So the site address is 3140 West Hollandale Beach Boulevard, Lot 601, Pembroke Park, Florida. A notice of violation was sent out by regular mail by former code officer Eric Richwagon. So I have been reassigned to this case, and that date is January 28, 2024. A notice of formal hearing with a copy of the notice of violation. An affidavit of noncompliance was sent by certified mail March 28, 2024, posted to the property and town hall April 5th, 2024. So let me see the corrections here. So based on March 27, 2024, item number 1, installed canopy without a building permit. That has not been corrected. It has been modified, but there's no permit for the current canopy outside. Item number 2, prohibited outdoor storage. Remove pallet, chain link fence, and miscellaneous items from the property. There's still outdoor storage, so it hasn't been fully corrected. Item number 3, installed plastic shed, removed from premise. The plastic shed is still on the property. That has not been corrected. And there has been installation of an aluminum shed as of March 26, 24 without a permit. So that has not been corrected. My recommendation is to give them 60 days, if not a per diem fine of $100 and a $100 admin fee. All right, go ahead. State your name for the record.
Roger Perez.
And the woman next to you is?
It's my mother.
What's her name for the record?
Unia Garcia.
Okay, okay, you mentioned a prior owner?
Yeah, the second name that shows up on the letter, that's the previous owner.
Okay, but you, Roger Perez, are an owner?
The owner.
Okay. So we're here for the violations.
She did tell me that they removed the plastic shed. Regarding the canopy and the aluminum shed, she did tell me that that she wanted to try to get a permit for them. She wasn't aware, as they were already sold like that, the house, and I guess now that she knows, she'll apply for the permit.
So the town is recommending 60 days to come into full compliance or a $100 daily fine.
Yeah.
Okay. You have anything else to add?
Tú que vas a aplicar por el permiso, ¿no?
Sí, claro.
Do you have an idea or an estimate of how much the permits are? Or
I do not. You'd have to.
Yeah, you will have to go to the building department because they're gonna ask you to bring in plans, job values, and details like that.
That's here?
Yes. So once you provide that, they can estimate the price of the permit.
Para sacar los permisos vas a tener que venir aquí para sacar los permisos con los
Ya
planes
que
y
yo
todo.
compré eso, estaba ahí, nadie me dijo que estaba legal o ilegal.
Okay, that's fine.
Okay. You have anything else? Okay. Based on the testimony evidence presented, there is substantial and competent evidence to support the town's position that violations exist on the subject property. You are ordered to come into compliance within 60 days or face a $100 daily fine. You are assessed a $100 administrative fee for today's hearing.
Okay.
Okay.
Within those 60 days, she does get the permit. Does she have to show up to a next hearing, or how does she go on about it?
So it's not just, the 60 days is to come into compliance, which means pulling the permits, having the work done, having the work inspected, notifying the officer when the permit is successfully closed out, so that if that's not done within 60 days, your daily fine will start accruing. Okay, and if you find that you need more time, but you're working diligently to get the work done, please notify Officer Ramirez.
Okay.
Okay?
Thank you so much.
You're welcome.
Thank you. Next case is on section 7.1 of the agenda, case 6619. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 6619, property owner Ramon Hernandez. Site address 3140 West Hallandale Beach Boulevard, lot 334, Pembroke Park, Florida. A notice of violation was sent by regular mail January 28, 2022. A notice of formal hearing with a copy of the notice violation and affidavit of non-compliance were sent by certified mail March 28, 2024. Posted to the property and town hall April 5th, 2024. The items are item number 1, installation of commercial cameras without a building permit. The item has been corrected. Item number 2, installation of addition without a building permit. That violation has been removed. Item number 3, installation of wooden deck porch without a permit. That has not been corrected. Item number 4, installation of 3 AC mini splits. That has not been corrected. Item number 5, installation of sky roof without a building permit. That has not been corrected. Item number 6, installation of new toilet and sink without a permit. That has not been corrected. Item number 7, alter structure by closing door exit and adding window without a building permit. That has been completed. And then added new door. That has been completed. And add grass sod to bare spots around the mobile home. That has not been corrected. So let's see here. There's still 1, 2, 3, 4 items that still need correction. So it's my recommendation to give them 90 days to correct those remaining items. If not, a per diem $100 and a $100 admin fee.
Good morning again. If you could please state your name for the record. Speak into the mic, make sure the green button is lit.
Good morning. Good morning.
Your name?
Ramon Hernandez.
Ramon Hernandez?
Yes.
And Humberto?
Humberto Ramos, I'm his architect.
Okay. Who's speaking on the violation?
I will go ahead and speak. We went ahead and submitted plans for the remaining things that require a permit to either legalize or just to address it. We submitted plans towards the end of last year or a little bit before the end of last year. Unfortunately, at the end of last year, the gentleman that lived in the trailer passed away. And so it's taken us a while to kind of recuperate and resume the process. But we have the plans ready. I will be resubmitting to address the comments that we received within the next day or two. Simple comments, so I expect to have approval by then. He has already purchased the air conditioners, so we're ready to go as soon as we receive the permit. He's going to replace the illegally installed mini splits with new ones that are code compliant. The deck will also be rebuilt. It's pretty deteriorated. The deck was always there from the time that he purchased the trailer, but we're going to go ahead and rebuild it and bring it up to code. And the skylight was always there, and it was always there. It's not something that he installed. If that's an issue, then I guess my suggestion would be to remove it and just kind of roof over that.
I will check. We do have, I believe, like as of a year ago, we do have a building official that, has been working with us. I can run it by him because I did run it by the previous building official, but I would like to run it by this building official to see his discretion on the skylight roof.
Okay.
So based on his discretion is how we can move forward.
Okay. And then finally, with regards to the sod, in this area, there's a very dense oak tree canopy. So my concern is if we put down any kind of sod, unless it gets significant amount of water, it's gonna die. So I was wondering, is there some other treatment that he can, some other ground cover or something that's native that might, live without excessive. Apparently, the trailer park restricts how much water they can use. They recently put meters on sub-meters on every trailer.
Okay.
And so they kind of limit them. So I don't think he'll be able to use it for constant irrigation, maybe just initially to get it going. Does it have to be sod or can we propose something different?
I will have to check with the zoning because I know that 25% of the lots have to have some form of landscaping. So as to if it's sod or something else, I will have to check on that.
Okay.
Yeah.
Okay. Anything else?
No, it's all right. It's only the process is a little more big because my father is dead. It's very sad because he, at the desk.
Yeah, sorry to hear that.
Oh,
Is the reason.
Okay.
I'm sorry for your loss.
So he still wants to address all the violations and he will use the trailer for himself. He lives in Ireland.
Oh, wow.
So that kind of also complicates the process a little bit, but we've been communicating and we're working on this to resolve it.
It's complicated because I work in department for affair for the government island.
Oh, okay.
For the embassy. It's a very complicated move here because every time I'm busy. For example, yesterday I called for the minister, missing myself. I'm back Saturday because on Monday I'm going the president home because I have a meeting. This is the reason sometimes very close move here because the object is only one and buy this for my father. This home for because it's very old. From nowhere about because I am support continue. This what I'm paid every month. No, only one if it's that's okay. It's my idea.
Understood.
Okay.
So the town is recommending 90 days to come into full compliance, or the daily fine amount will accrue at $100 a day, will run at $100 a day, and there will be a $100 assessed for the administrative fee for the hearing, okay?
Okay,
If that time is not, if you're working diligently but not achieving, please stay in contact with Officer Ramirez.
will do.
So my oral pronouncement is, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that violations exist on the subject property. The respondent is ordered to come into compliance within 90 days or face a $100 daily fine. The respondent is assessed $100 for today's hearing. You can step over and we'll give you a copy of the order.
Thank you.
You're welcome.
Thank you.
Thank you
Sorry
very much.
again for your.
Our condolences.
Ms. McKinney, for the record, there's no one else signed in and no one else here in the room or respondents present.
You want to take a 5-minute recess? Good luck.
Yes, I'll take a 5 minute since I. Yeah.
Apologies that we don't have police presence, but I know that the department is struggling with staff. You know what? I know I don't have to sleep, and I don't know if it's gonna be that. You guys do active shooting drills? You haven't done that? Yes. Every. Oh my gosh. I haven't done it for like several years. For the match. All employees, town council, because we didn't know if it's a lockout that has a place.
just final touches. You wanna go see it?
I would. In my mind, I remember what it looked like when
Remind me after with the.
I took a little tour.
Yeah, they already gave us a
Because
tour.
remind me, Jocelyn, Chambers is moving upstairs?
Chambers? No.
Oh, okay. They're still gonna convene here?
Yeah. Oh yeah, there was a plan, but it wasn't executed.
Oh, okay, okay. I'm like, am I making that up or?
Yeah, there was a plan to do like an EOC on the third floor. Is that what you recall?
Yeah.
And using it for magistrate as well.
Yes, remind me. Is the town full service? You guys don't have a water plant? Okay.
Broward County does the water service.
And Broward does your firefighting?
BSO does our fire inspections. We have 2 fire inspectors here from BSO. And yeah, we have.
They are on site?
Yeah, we have 2 fire inspectors that are on site, but as far as like the firefighters, that comes from.
the sheriff.
Yeah. We normally have Chief Kane. Do you know Chief Kane? Okay. Oh, did you get the job at Walter Manors?
I did.
Okay, good.
Did they reach out to you?
Yeah, they did. Did you put me as a reference? Or they just knew? Huh?
I did.
Did you put that you work in the town of Pembroke Park?
I did.
That's probably what it was.
I did. It's funny because I did include references on my resume. I do list. I did the company. But honestly, they did not reach out to any of my references.
Only the ones that I think they reached out to who you worked for.
Yes, I realized.
And Harry Kepler too. He said he got a job in Walter Manors.
So so you know how the town alternates? They do too. So between 3, the woman magistrate, I don't know her. I think she's retired from the practice of law. So I don't know her in terms of local government. And I think her office is either in Walter Manors or not too far. I got to shadow her, like I did magistrate with her. And so that was good. Just seeing each city is so different, but yet the same and everything. They have a nice chamber like you guys do, also. And yeah, it's funny because I don't think Magistrate and I even knew that we interviewed until after the fact, and everything. So yes. So I don't know what you said. I'm not going to ask, but I'm glad they were able to reach reliable and credible.
I just said that you were fair. You have fair judgment. You hear both sides, and you have fair judgment. And they were like, okay, that's what we want. But I know the supervisor there personally, because the supervisor for code over there, Abel Avera.
Oh, did you work with him at the?
I worked
he
with
was
him
here.
when he was in Westmore.
But he also worked in Dade County too.
But I worked with him when he was in Westmore, and we would tag team because, like, if he saw anything in the town of Pembroke Park, he'll let me know, and if I saw something hit, so we will work together to get it resolved.
Oh, yeah. Abel is amazing.
He is.
Super awesome. And everything. A lot of experience. The whole team. I truly have to say. And everything.
He tells me every day, he's like, I got this job because of you. I was like, no, you got it because of you. He's like, no, I wasn't going to apply until you told me, just do it. Like, you never know. And he ended up getting it.
I think I said this before. You remind me of, and I don't know if you see her in any of your conferences, Corinne Yoder. She's the senior. She's you at Howlandale, the senior code compliance.
Oh, I think I've talked to her on the phone. Something happened, some issues that we're still like. Mine is constant conversation. Yeah. He's nobody hearing. Nobody's the bad thing is we can't cut it off. No, that's
it's just like in criminal court, they have you notice, even if you whisper.
alright. Yes.
Whenever we're ready to go back on the record.
Okay. Since no one's present in the audience, we're gonna go by the order of the agenda. So that the first case would be on section 7.7, case 8072. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park. Case 8072, property owner Alan Carrier and Jacqueline Carrier. Site address 4861 Southwest 26th Court, Pembroke Park, Florida. A notice of violation was sent by regular mail January 12, 2023. A notice of formal hearing with a copy of the notice of violation and affidavit of noncompliance were sent March 28, 2024 by certified mail, posted to the property and town hall April 5th, 2024. The violation is for installation of AC unit without a permit. There was a previous permit. However, it's expired, so they have to complete it. I got a phone call yesterday by Noel Vendries. He's the mechanical contractor. He told me that he reinstated the permit and that it should be completed within 30 days. So therefore, my recommendation is to get 30 days, a per diem fine of $100 and a $100 admin fee.
Case number 8072, property 4861 Southwest 26th Court, Pembroke Park, Florida. Let the record reflect there is no one present in chambers for this case. Based on the testimony evidence presented, there is substantial competent evidence to support the existence of a violation on the subject property. The respondent is ordered to come into compliance within 30 days or face a $100 per day daily fine. The respondent is assessed $100 for today's hearing. Next case.
Next case on 7.8 on the agenda, case 8073. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 8073, property owner Line Doyon, Gayton Labe, site address 4873 Southwest 25th Court, Pembroke Park, Florida. A notice of violation was sent by regular mail January 12, 2023. A notice of formal hearing with a copy of the notice of violation and affidavit of noncompliance were sent by certified mail March 28, 2024, posted to the property and town hall on April 5th, 2024. The violations is for installation of the AC unit without a permit. Again, there was a previous permit, but it expired. And it's the same contractor, Noel Vendis. He reinstated the permit and also needs 30 days to complete it. So therefore, 30 days with a $100 MF fee and a $100 per diem fee is suggested.
Case number 8073, let the record reflect. No one is present for case number 4873, Southwest 25th Court, Pembroke Park, Florida. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position that a violation exists on the subject property. Respondent is hereby ordered to come into compliance within 30 days or face a $100 per day daily fine. Administrative costs in the amount of $100 are assessed for today's hearing. Next case.
Next case on the agenda is Section 7.11, Case 9235. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, Case 9235. Property owner Nation Dom Inc., site address 5100 Southwest 41st Street, Pembroke Park, Florida. Unit 306. A notice violation was sent by regular mail of February 9, 2024. A notice of formal hearing and a copy of the notice violation with an affidavit of non-compliance was sent by certified mail March 28, 2024, posted to the property in Town Hall April 5th, 2024. This is a repeat offense referencing case 6185 that has been, the final order has been entered into the record. And the violations are as follows. Item number 1, damaged ceiling and leak area in bedroom and bedroom closet with mold-like substance infestation. Repair ceiling and remove mold-like substance. Provide mold-like substance remediation report upon reinspection. This has not been corrected. Item number 2, modify ceiling in closet, bathroom, and kitchen area. Obtained after the fact permits. That has not been corrected. Item number 3, added can lights and alter electrical in bathroom area. This has not been corrected. Item number 4, entrance door has mold-like substance infestation. That has not been corrected. Item number 5, installed water heater without a permit. That has not been corrected. Item number 6, AC unit is not up to code and was installed without a permit. This has not been corrected. So item number 1 through 6 has not been corrected, and this is a repeat offense. Since there's a lot of items to be corrected, my recommendation is to give them 60 days, if not a per diem fine of $500 and a $100 MV.
Is there someone in the unit?
Yes, this violation began from a tenant complaint.
Case number 9235, site address 5100 Southwest 41st Street, Unit 306, Pembroke Park. Let the record reflect that the chambers are empty. There are no respondents in the chambers. Based on the testimony and evidence presented, there is substantial and competent evidence to support the existence of a violation on the subject property. The respondent is hereby ordered to come into compliance within 30 days or face a per diem fine of $500.
Yes.
Respondent is assessed $100 for administrative costs. Let the record reflect this is a repeat offense case number 6185. Next case.
All right. The next case is section 8.2. As stated earlier on the record, this case has been removed and has been changed to an extension of time. So following section 8.3 is the next case, case 4882. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 4882. Property owner Henry Gutierrez and Gloria Munoz. Site address 105 Flory Lane, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail April 4, 2024. Posted to the property and town hall April 5th, 2024. It is town's motion to confirm the fine of $38,800.
Case number 4882, site address 105 Lori Lane, Pembroke Park. Let the record reflect there is no respondent here on this case. Based on the testimony and the evidence presented, there is substantial and competent evidence to support the confirmation of the fine in the amount of $38,800. The violations remain outstanding on the subject property. Respondent is hereby ordered to come into compliance, or the daily fine will continue to accrue. Next case.
Next case is section 8.4 on the agenda, case 4885. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 4885. Property owner George Heredia and Sarela Montoya. Site address 111 Lori Lane, Pembroke Park, Florida. A notice of hearing to confirm fine and affidavit of noncompliance were sent by certified mail on April 4th, 2024, posted to the property and town hall April 5th, 2024. It is the town's motion to confirm the fine of $47,400.
$47,000?
$400.
Thank you. Case number 4885, site address 111 Lori Lane, Pembroke Park. Let the record reflect there are no respondents for this case. Based on the testimony and evidence presented, there is substantial and competent evidence to support confirmation of the fine in the amount of $47,400. The property remains out of compliance. Respondent is ordered to come into compliance, or the daily fine will continue to accrue. Respondent is assessed $100 for today's hearing. Next case.
Okay, next case is on section 9.1 of the agenda, case 4381. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 4381. Property owner Holiday Hallandale MHC LLC, site address 3140 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice form of hearing to extend time was requested via email April 12, 2024. It is the town's motion to extend the time by 30 days. If not, a per diem of $250 and $100 admin fee.
And I saw in the file that the respondent did submit that in writing.
Yeah.
So this is considered a joint motion, or a joint request, rather.
Yes.
Okay. I just like the record to be clear, because it does bear. Case number 4381, site address 3140 West Hallandale Beach Boulevard, Pembroke Park. Based on the agreement of the parties, this is a joint request to extend the time for compliance by 30 days, or the respondent shall face is it $250?
Yes.
A $250 per diem daily fine. The respondent is assessed $100 for today's hearing. Next case.
That concludes all the cases. However, I wanted to correct something for the record. Section 10.1 is case 6829. And section 10.2 is case 8595. So the one that needs to be corrected is section 10.2, because the case that's written on section 10.2 is case 6829, but will be administratively corrected to case 8595.
And the record does reflect that the respondent was present for both cases.
Yes.
And so that's duly noted for the record.
All right.
Nothing else? We're adjourned. 11:49.